the subcommittee will come to order without objection. The chair is authorized to declare recesses of the subcommittee at any time. Welcome to this morning's hearing on civil enforcement of congressional authorities. Before we begin, I'd like to remind members that we have established an email address and distribution list dedicated to circulating exhibits, motions, or other written materials that members might want to offer as part of our hearing today. If you'd like to submit materials, please send them when you are not speaking. This will help prevent feedback and other technical issues. You may unmute yourself anytime you seek recognition, and I will now recognize myself for an opening statement. Today, I convene the subcommittee for a bipartisan hearing on civil enforcement of congressional authorities. This is an important issue for the committee, for the institutional interest of Congress, and for the enduring strength of our constitutional system. When Congress asks for information, it expects to receive it. Congress cannot effectively or fully carry out its constitutional duties of legislating or oversight without the information it needs to do its job. An essential part of Congress's oversight and investigative authority is the power to compel testimony and documentary information, including the power to issue and enforce subpoenas. The Supreme Court has explained, quote, that mere requests for information often are unavailing, and also that information which is volunteered is not always accurate or complete. So some means of compulsion are necessary to obtain what is needed, end quote. None of this is to say that Congress can operate carte blanche. Courts have recognized that certain constitutional privileges, protections, and safeguards exist in the congressional subpoena process. And normally, the most expeditious way to obtain information is through negotiation and settlement. The accommodation process is the bedrock of congressional investigative activity, particularly when those investigations focus on the executive branch. What recent history has taught us, and what we will hear more about from the witnesses appearing before us today, is that when the process takes too long, it breaks down and impedes Congress's constitutionally mandated work. Timing is often critical because Congress operates in 2-year cycles and a presidential administration can last for as little as 4 years. There's something wrong when we can assume that a court case to enforce a congressional subpoena will last longer than the Congress that issued the subpoena, or even the presidential administration defying it, no matter when the subpoena was issued. I'd be remiss if I did not note the political nature of some of the investigations that inform today's hearing. They include different branches of government controlled by different parties. We may not all agree on the purpose, scope, or tenor, or even propriety of these investigations, but what I hope we can all agree on is that the process is important. Congress cannot function without information to support its legislative efforts. The institutional interests of Congress are at risk when, in practical effect, the executive branch can control the investigative process, especially when engagement by the judicial branch occurs too slowly. The courts are well equipped to resolve disputes over subpoenas. At bottom, subpoena enforcement is a basic judicial task which federal courts are very familiar with. This is true even when a case involves co-equal branches of government, as disputes over congressional subpoenas often do. Recent history, however, suggests that courts may need some additional direction, particularly given the timing sensitivities surrounding congressional subpoenas. I look forward to hearing from our witnesses to understand where we are today as we look for solutions to reinforce Congress's power to compel the production of testimony and documents when negotiations break down. I started by saying that this is an important bipartisan issue for the committee. I know that this is an issue important to our ranking member, Mr. Issa in particular. He has invested a lot of time personally in looking for solutions and a lot of energy in trying to make those solutions into law. I thank him for his work on the enforcement issue and look forward to a productive hearing. Also, without objection, I'd like to enter into the record a statement from Ann Tyndall and Grant Tudor at Protect Democracy, titled Modernizing Congress's Subpoena Compliance and Enforcement Methods. Recognition of ranking member, with that, I will now recognize the gentleman from California, the ranking member of the subcommittee, Mr. Issa, for his opening statement.
Thank you, Mr. Chairman, and thank you for holding this important hearing and with the legislation that is anticipated. Once again, Congress will show that it can work on a bipartisan basis to do its job. The first investigation conducted by Congress was not one that had controversy as to the two branches, but rather Congress under President George Washington was asked to investigate in 1791 the loss in an Indian war by the United States, because the president could not, by definition, trust his generals to investigate their own failure. That, like so many others, represent probably 70 or 80% of all investigations, ones in which the executive branch not only complies, but often wants a result. But congressional subpoenas are more than just the requirement that we see in oversight. They are, in fact, essential to the job we do. We cannot authorize the spending of trillions of dollars and not expect that somewhere among the millions of people who call the federal government their employer, whether as a contractor or as an employee, we can't expect that there won't be a few bad actors. Over the decades, Congress has successfully investigated everything from, if you will, under Henry Waxman, countless different examples of waste, fraud, and abuse. My own tenure exposed many, but also when conflicts arise as to the conduct of the office itself, such as with John Conyers, and when he called for and took 2 years to get Harriet Miers to comply, we in fact constantly find ourselves with what the chairman referenced, which is delay is in fact the equivalent of denial. Currently, we have a system in which each time we move to compel, whether in the private sector or with the government, we are treated often less well than a common FOIA request. Under FOIA, an Article 3 judge fairly quickly finds himself having to make a decision about whether the executive branch is to comply. In the case that I have had experience with, we have had as much as 2 years delay in a judge deciding whether or not they're going to hear it and what the width of that hearing is going to be. I believe there's a consensus within the Congress that in fact, even if we disagree with one chairman or another chairman's subpoena, that we would like it handled quickly and in a way that we can believe is just and not partisan. Only through quickly and effectively implementing it when there's a dispute between the two branches, an Article 3 judge, or in the case of a private individual, the fact is an Article 3 judge can hold someone in contempt if they refuse to comply with a subpoena. Well, in fact, our contempt has no teeth in it unless the executive branch agrees and prosecutes the individual. Our legislation, therefore, must have 3 elements. 1, the participation of of Article 3 judges. 2, a timeline. And 3, a process that if in fact either side is not satisfied with the initial decision, that it be expeditiously reviewed so that there can be certainty. Mr. Chairman, I appreciate this hearing coming in the early part of this Congress. so that hopefully before this Congress is over, we can in fact, on a bipartisan basis, once and for all, move ourselves toward a predictable process for discovery, whether it's through the executive branch discovery or private individuals. And I join with you and many chairmen of the past who have been frustrated by the process and want to see a predictable process going forward. So again, thank you, Mr. Chairman. I yield back.
Thank you, Mr. Issa. We share that aspiration. And with that, I will recognize the chairman of the full committee, the gentleman from New York, Mr. Nadler, for his opening statement.
Well, thank you, Mr. Chairman. I want to thank you for holding this important hearing, and I share your commitment to protecting Congress' place in our constitutional system. I hope this hearing will demonstrate that ensuring Congress has the tools it needs to enforce its subpoenas transcends partisanship. Nearly a century ago in McGrain versus Dougherty, the United States Supreme Court framed the responsibility of congressional oversight this way. A legislative body cannot legislate wisely or effectively in the absence of information respecting the conditions in which the legislation is intended to affect or change. And where the legislative body does not itself possess the requisite information, which is not infrequently true, recourse must be had to others who do possess it, unquote. Congress' authority to obtain information, including by use of compulsory process, flows directly from its Article I legislative function. In 2017, I spoke on the House floor in support of the Congressional Subpoena and Enforcement Act of 2017, a bill that was first introduced by the gentleman from California, Mr. Issa. What I said then holds true today. It is our responsibility to ask for the information we require to do our jobs effectively, and the Constitution empowers us to enforce those requests if we are at first denied. In other words, if Congress cannot reliably enforce its lawfully issued subpoenas, our constitutional structure has been profoundly undermined. In many instances, Congress and the party from whom it seeks information, frequently the executive branch, have been able to reach an agreement without resorting to litigation. This is certainly the preferred outcome. But sometimes, whether because of stonewalling or legitimate disagreement, there is no other option. It should go without saying that time is of the essence when a congressional committee seeks judicial enforcement of its subpoenas, and that delay can be as damaging to a congressional investigation as an unfavorable ruling. Responsible congressional investigators are constantly juggling the need to uncover the facts against having enough time to translate those facts into legislative action. If we do have to file suit, it is essential that our lawsuit be resolved quickly. Unfortunately, recent subpoena enforcement cases have taken years to reach resolution. The Judiciary Committee's suit to secure the testimony of Don McGahn, former President Trump's White House counsel, is a case in point. In one sense, that suit ended with a victory for congressional oversight. We negotiated a settlement with the Justice Department that resulted in Mr. McGahn sitting for a transcribed interview last Friday. We made clear that the executive branch must respect our subpoenas, that there is no such thing as absolute immunity from congressional testimony, and that congressional investigators will eventually secure their witness in response to appropriately issued subpoenas. But our victory also highlighted the deficiencies in the civil enforcement process that I've just described. It took 2 years to enforce a subpoena, and Mr. McGahn's interview happened more than 4 months after the president he served under left office. Excuse me. That is an unacceptable delay. Modern experience has taught us that although effective congressional oversight is essential to a functional democracy, Congress can no longer simply assume good faith cooperation with our committees and swift enforcement of our subpoenas in federal court. Congress needs to take a hard look at how to ensure that its fundamental power to investigate will survive in an era of unprecedented stress on our democratic institutions. To be sure, not every investigation is equally worthwhile, and not every subpoena may be immune from challenge. But Congress' constitutional authority to investigate and to enforce its valid subpoenas must be incontestable. I thank the chairman and the ranking member for the bipartisan nature of this hearing. I look forward to hearing from our witnesses about these important issues. And with that, I yield back the balance of my time.
Thank you, Mr. Chairman. I'll now introduce our witnesses. Ms. Elise Bean is a director of the Washington, D.C. office of the Levin Center at Wayne Law, which she helped establish after Senator Carl Levin's retirement from the Senate. Ms. Bean has more than 30 years of experience working as an investigator for Senator Levin, including more than a decade as his staff director and chief counsel on the U.S. Senate Permanent Subcommittee on Investigations. In that role, Ms. Bean handled investigations, hearings, and legislation on a wide variety of matters, including money laundering, offshore tax abuse, corruption, shell companies, and corporate misconduct. Ms. Bean earned her Bachelor of Arts from Wesleyan University and her JD from the University of Michigan Law School. Welcome, Ms. Bean. Thomas Hunger is a partner in the Washington, D.C. office of Gibson, Dunn and Crutcher, LLP. His practice focuses on appellate litigation, complex trial court litigation matters, and congressional investigations. Mr. Hunger previously served as general counsel of the U.S. House of Representatives, providing legal advice and representation on a nonpartisan basis to the House and its leadership, members, offices, and staff, and worked closely with House committees on oversight and investigative activities. He also previously served in the office of Solicitor General, including as Deputy Solicitor General. Mr. Hunger received his Bachelor of Science degree from Willamette University and his law degree from Yale Law School. Welcome, Mr. Hunger. Praveen Fernandez is Vice President at the Constitutional Accountability Center, CAC. Before CAC, Mr. Fernandez was a principal at the Raven Group, where he advised nonprofit clients on issues including LGBTQ equality, criminal justice, wealth inequality, digital equity, and judicial nominations. Mr. Fernandez also served as senior counsel and advisor to the general counsel at the Office of Personnel Management during the Obama administration. He began his career on Capitol Hill, where he served on Senator Edward Kennedy's Labor Committee staff. Mr. Fernandez earned his undergraduate degree from Brown University, a master in public health degree from the University of North Carolina Gilling School of Public Health, and his JD from the University of North Carolina School of Law. Welcome, Mr. Fernandez. Mr. Todd Garvey is a legislative attorney with the American Law Division of the Congressional Research Service, where he provides nonpartisan analysis to members of Congress, staff, and congressional committees. Mr. Garvey specializes in issues dealing with congressional oversight and investigations and constitutional separation of powers. He has written extensively on congressional subpoenas and compliance by executive branch officials and on Congress's contempt power. Mr. Garvey received his undergraduate degree in political science and government from Colgate University and his JD from the William and Mary Law School. Welcome, Mr. Garvey. Before proceeding with testimony, I'd like to remind all of our witnesses appearing today that you have a legal obligation to provide truthful testimony and answers to this subcommittee, and that any false statement you make today may subject you to prosecution under Section 1001 of Title 18 of the United States Code. Please note that your written statements will be entered into the record in its entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. There is a timer in Zoom to help you stay within that time limit. Mr. Bean, you may now begin.
Thank you very much. I appreciate this opportunity to testify.
I'm sorry,
Oh.
Mrs. Bean, I'm sorry.
Thank you very much. I appreciate this opportunity to testify about the need to strengthen civil enforcement of congressional subpoenas, in particular subpoenas directed to the executive branch. As a longtime congressional investigator, I know how important this issue is. The problem, as has already been described, is that the executive branch, their compliance with congressional information requests has continued to erode. A couple of examples. last year, Senator Toomey led the filing of a bipartisan amicus brief challenging a decision by the Commerce Department to refuse to release a report on auto tariffs, even though a statute required that report to be published in the Federal Register. Despite that law, the Commerce Department just refused to provide the report, still refuses today, and the Department of Justice, through its Office of Legal Counsel, has issued an opinion sustaining the position of the Commerce Department. Another example from last year, the Department of Justice just refused to appear at a hearing before the House Judiciary Committee. The Assistant Attorney General for Civil Rights, the Director of the Bureau of Prisons, and the head of the U.S. Marshal Service refused to appear at an October hearing because, as was said in a letter from the Justice Department, quote, the Judiciary Committee had squandered its opportunity to conduct a meaningful oversight hearing with the Attorney General, end quote, the month before. So they chose not to appear. And of course, we're all familiar with the White House assertion that former White House counsel Don McGahn was absolutely immune to any congressional subpoena and did not have to appear even to assert executive privilege. And that's a stance that has been taken by presidents of both parties for over 50 years. And finally, as mentioned earlier, the Fast and Furious case, a House oversight investigation led by Congressman Issa. They issued a 2011 subpoena to the Department of Justice. When that was not fulfilled, they filed a lawsuit in 2012. They litigated that actively for 4 years until 2016, and the case itself was not fully closed until 2019. So that's a 7-year journey through the federal courts. And as the executive branch becomes increasingly confident that courts won't step in to enforce a congressional subpoena, even in egregious cases, then the executive branch becomes increasingly dismissive of the accommodations process because they know refusing to provide the information will have few, if any, consequences. Congress can fix this problem. They can do a lot to make their ability to get information better. In my written statement, I give you a long menu of different options, but I want to just mention, and I put them in 3 categories: enacting better laws when it comes to civil enforcement, creating new penalties, such as civil fines, and streamlining judicial review. But I want to mention just 3 out of that long list of options. The first is to codify Congress's right to file civil enforcement actions in federal court. It's hard to believe that there is no statute on the books today that allows the House to do so. And the Senate statute exempts subpoenas to the executive branch. Congress, in light of the Mazars decision by the Supreme Court and the McGahn en banc decision from the DC Circuit, this creates a very good moment to pass that type of legislation, especially with a president in office who acknowledges and understands the need Congress has for accurate information. Second, Congress could enact a statute to expedite judicial review. There are several bills, one of which passed the House in 2017, that would create a statutory duty of the courts to expedite cases involving congressional subpoenas. One of the bills actually says the Judicial Conference and the Supreme Court must issue rules, actual rules, to make sure that that happens. That's a very good way to go. And finally, Congress could codify a small set of rules for the executive branch compliance with congressional subpoenas. For example, there is no absolute immunity to congressional subpoenas. And if you're going to assert executive branch privilege, the president needs to do that in writing, and there needs to be a privilege log or the privilege will be waived. Even a larger thing that Congress could do is to create a congressional counterpart to the Department of Justice Office of Legal Counsel so that they can issue official opinions on oversight issues, including with respect to subpoenas. If they issue opinions that are bipartisan, bicameral, thoughtful, well-supported, you could provide guidance not only to Congress and the executive branch, but also strengthen the hand of Congress and the courts. Thank you for delving into this very important subject to revitalize Congress's ability to get the information it needs to make informed decisions. Thank you.
Thank you. And we will now hear testimony from Mr. Hunger. Mr. Hunger, you may begin.
Thank you, Chairman Johnson, Ranking Member Issa, Chairman Nadler, members of the subcommittee. I appreciate the opportunity to appear before you today to testify about the important topic of the enforcement of congressional subpoenas. In my former role as House General Counsel, I experienced firsthand some of the many obstacles, frustrations, and delays that the Congress frequently encounters in attempting to obtain information from the executive branch pursuant to its legitimate oversight requests. I hope this hearing will assist the committee and the House in identifying potentially viable solutions to that pressing problem. Congress's constitutional authority to compel testimony and production of documents in response to oversight requests is beyond dispute, and the permissible scope of congressional inquiry is, in the Supreme Court's words, as penetrating and far-reaching as the potential power to enact and appropriate under the Constitution. In fact, the court has said that legitimate oversight encompasses inquiries concerning the administration of existing laws, as well as proposed or possibly needed statutes, surveys of defects in our social, economic, or political system for the purpose of enabling the Congress to remedy them, as well as probes into departments of the federal government to expose corruption, inefficiency, or waste. Unfortunately, however, in the past dozen years or so, it has become increasingly clear that the traditional mechanisms for encouraging executive branch compliance with congressional requests for information are no longer adequate to the task. Imprisonment for inherent contempt, for example, is widely viewed as impractical and unrealistic, and the executive branch refuses to prosecute federal officials for criminal contempt, rendering those traditional tools effectively useless in the oversight context. As a result, the House has been forced to resort to civil enforcement actions, but that mechanism has also proven to be unsatisfactory in many instances because, among other reasons, the Department of Justice's litigating tactics, continuing areas of legal uncertainty, and the discretionary scheduling decisions of federal judges can lead to inordinate delays and unduly limited relief, effectively defeating Congress's oversight efforts.
Mr. Hunger, you are now over your time. If you could sum up, please.
Yes, Mr. Chairman, I set forth in my written testimony various proposals for remedying this situation, including legislation that has previously been proposed, and we'll be happy to address the committee's questions about any of those issues. Thank you.
Yeah, Mr. Hunger, I am in error. That message I got pertained to the last witness, and so you have 2 minutes. So please proceed. I'm so sorry.
Thank you, Mr. Chairman. So just to flesh out briefly, some of the proposed solutions that have been offered and that could help address this problem include the following. So first, legislation could be enacted to reinvigorate the inherent contempt procedure by providing for the imposition of fines or the preclusion of salary payments when a federal official is found in contempt of Congress after appropriate House or Senate proceedings. Second, legislation along the lines of the Congressional Subpoena Compliance and Enforcement Act that passed the House in 2017 could be enacted, with provisions designed to eliminate meritless legal objections that the Department of Justice currently seeks to advance in subpoena enforcement actions, ensure expedited judicial resolution of civil enforcement actions at every level of the federal courts, permit congressional committees to obtain direct Supreme Court review, thereby minimizing appellate delays and avoiding the intermediate step of going to the federal courts of appeals. And finally, require the executive branch to specify, as Ms. Bean said, to specify its claims of privilege promptly or be deemed to have waived them so as to prevent the types of delaying tactics that the Justice Department has used to considerable effect in the past. And third and finally, the House could modify its appropriations procedures to ensure that the appropriations power is wielded in a manner calculated to incentivize prompt compliance with legitimate congressional subpoenas. Thank you.
Thank you, Mr. Hunger, and sorry for that interruption once again. We will now hear from Mr. Fernandez. Mr. Fernandez, you have 5 minutes, sir, and you may begin.
Thank you. I would like to thank the chairman, ranking member, and other members of the subcommittee for the privilege of offering some thoughts as you consider congressional oversight and the enforcement of subpoenas. Congressional investigatory power is deeply rooted in our political system and is embedded in our Constitution, which grants Congress the right to legislate. But there's a problem. Over the last 4 decades, there has been a congressional oversight effectiveness crisis, particularly with respect to oversight of the executive branch. Executive branch officials have refused to comply with subpoenas, and resolution of these disputes in the courts has taken too long. An example proves instructive. In early 2019, the House Oversight Committee subpoenaed Mazars USA for documents related to the President Trump's and his business's finances. In the ensuing litigation, the House won at the district court and circuit court levels. In July 2020, the Supreme Court held, in accordance with precedent and centuries of history, that Congress has broad investigatory powers and can investigate the executive branch and indeed even the president himself. However, because the court concluded that the lower courts had not properly taken into account separation of powers concerns, the court also vacated the lower court's opinion and remanded the case. And now, more than 2 years after the start of the lawsuit, the issue is nowhere near resolved, and there's still a pending motion for summary judgment at the district court level. This is just one example, which I'm providing simply because of its ongoing nature and because it was litigated at every level of the federal court system. How one feels about any given example might be influenced by one's partisan affiliation, one's feelings about a presidency, or one's commitment to the underlying subject matter. But the problem is larger than any subject, political party, or presidency. In countless cases, delays in the courts have prevented Congress from receiving the information to which it's entitled and which it needs to do its job. The consequences of such delays are particularly acute in the House, which is not a continuing body. Each time a new House is sworn in, its ongoing investigations end and its subpoenas expire. If new leadership decides not to reissue subpoenas, the ongoing litigation could be mooted, foreclosing the chance of the House receiving the information. One possible solution is for Congress to establish a pathway for expedited court review of oversight disputes. Congress has considered this option before. For instance, Congresswoman Dean in the last Congress and Ranking Member Issa in the 115th Congress introduced legislation that would streamline the process of resolving disputes over subpoenas. According to both legislative proposals, anytime the House, Senate, or one of its committees or subcommittees brings a civil action against the recipient of a congressional subpoena, the federal courts at every level must expedite disposition to the greatest possible extent. Both pieces of legislation further provide that if requested by the plaintiff, the action shall be heard by a 3-judge court and shall be reviewable by appeal directly to the Supreme Court. The bills also require notice of appeal to be filed within 10 days. Allowing for expedited review and a direct appeal to the Supreme Court would allow for a quicker and more efficient process when it comes to enforcing congressional subpoenas. This streamlined review has precedent. For example, 28 USC section 2284 allows for a 3-judge panel for actions challenging the constitutionality of apportionment of congressional districts or apportionment of any statewide legislative body. In addition to making provision for a 3-judge panel and streamlined appellate review, Congress should consider clarifying that this pathway would govern regardless of any other statutory schemes implicated by the subpoena. To cite just one example, documents created or maintained by the White House are subject to the Presidential Records Act, which sets out its own procedures for resolving disputes. Congress should make clear that other statutory schemes notwithstanding, disputes over congressional oversight in the federal courts will be resolved through the expedited pathway. In conclusion, Congress's right to obtain information is not in doubt. What is in doubt, however, is whether Congress will be able to obtain the information to which it is entitled in a timely fashion. Currently, when oversight disputes go to the federal courts, this remains an open question. Congress should consider expedited court review as one way of answering it. Thank you.
Thank you, Mr. Fernandez. We will now hear from Mr. Garvey. Mr. Garvey, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Chairman Johnson, Ranking Member Issa, members of the committee, thank you for inviting me here today to discuss the enforcement of congressional subpoenas. It is perhaps best, I think, to start this discussion by recognizing the potency of the subpoena power. A congressional subpoena is a constitutionally based demand for information that triggers a legal obligation on behalf of the recipient. In the words of the Supreme Court, all citizens, whether government officials or private persons, have a duty to cooperate with Congress and an unremitting obligation to respond to subpoenas. That obligation is lifted for what amount to only a handful of reasons. For example, where the committee lacks a legislative purpose or exceeds its jurisdiction, or where a specific and overriding privilege or right justifies withholding information from the Congress. Though the legitimate justifications for not complying with the subpoena may be few in number, they are rich in ambiguity. And with the courts historically playing only a limited role in adjudicating oversight disputes, these areas of uncertainty are ripe for conflict. There's perhaps no better example of this than executive privilege, a contested constitutional doctrine that frequently forms the basis for executive branch refusals to comply with congressional subpoenas. So disagreements between the branches inevitably develop. And when they do, the first phase is generally one of negotiation. This is sometimes referred to as the accommodations process, and it is a method of dispute resolution that derives both from long settled historical practice and arguably the Constitution itself. But compromise is not always possible. And when negotiations fail and subpoena obligations go unfulfilled, the ball is left in Congress's court. So when faced with noncompliance, this House has various options. It can look inward and leverage its own legislative powers to force compliance. This can take many forms, for example, by enacting legislative or appropriations restrictions, or by withholding consent to legislative or funding priorities until the subpoena is complied with. Though potentially effective, this can be a blunt and unwieldy enforcement tool. Alternatively, the House can look to the executive branch and refer a contempt of Congress citation to the Department of Justice for criminal prosecution. Failure to comply with a committee subpoena is a criminal offense, but like other criminal offenses, the power and discretion to prosecute lies with the executive branch. And it is now clear from recent history that in most instances, the executive branch is unlikely to prosecute an executive branch official for not complying with a congressional subpoena. As a result, the criminal contempt statute has lost much of its deterrent value. The obstacles associated with looking to either its own powers or to the executive branch have led the House to instead turn with increasing frequency to a third option, the courts. Today, it appears that civil enforcement, or the process of asking a federal court to order compliance with a congressional subpoena, has become the House's chief means of enforcement. But like the other options, this too has drawbacks. First, there is always the risk of an adverse decision. And in a legal environment with very few judicial decisions, one unfavorable opinion can significantly disrupt the long-term balance of power between the branches. But there's also the problem of time. The judicial process is generally not a fast one, so even when Congress wins, it may come too late. And because the executive possesses what Congress desires, delay favors the executive branch. Consider these past enforcement examples, all of which I know the members of this committee are familiar with. Beginning in 2008, this committee spent 18 months litigating a subpoena to former White House counsel Harriet Miers. Beginning in 2012, the House Oversight and Reform Committee spent nearly 7 years litigating a subpoena to Attorney General Eric Holder. And most recently, your committee has now spent 2 years litigating a subpoena to former White House counsel Don McGahn. Now, it's worth noting that each of these cases ended not with a final judicial decision, but with an accommodation or agreement between the branches in which the House generally obtained much of the information it sought. Ms. Miers testified behind closed doors. DOJ turned over most of the Fast and Furious documents, and Mr. McGahn sat for an interview last week. But the delay in obtaining the sought after information would appear to have frustrated timely congressional oversight. The process as it stands leaves the House and this committee with numerous questions. Should Congress be going to the courts to resolve these disputes? If yes, is the current process with all its uncertainty and delays acceptable? And if no, what alternative enforcement mechanisms are there? Thank you again for the opportunity to testify, and I look forward to your questions.
Thank you, Mr. Garvey. We will now proceed under the 5-minute rule with questions, and I'll begin by recognizing myself for 5 minutes. Ms. Bean, my first question is for you. The focus of this hearing is on strengthening Congress's investigatory powers, but I think it's important to note that how Congress uses those powers can affect how those powers are viewed in court. What are some of the hallmarks of a serious congressional investigation of the executive branch?
Well, of course, a bipartisan stance is the most important thing. I think if Congress had some official legal opinions about how the executive branch ought to respond to congressional subpoenas, we have so much turnover in staff, and often there's turnover in the members of Congress, that people don't know what are the norms, what is acceptable, what kinds of negotiating goes on in the accommodations process. So I think having better guidance would also help. Other hallmarks are having, this bipartisan, having joint subpoenas, having a joint report, having a hearing that has bipartisan elements. All of those things increase public perception and maybe judicial perception of how legitimate the information request is.
Thank you. Ms. Bean, I have a second question building on that same theme. Why will the accommodation process continue to be important, even in situations where a committee goes to court to enforce its subpoena?
Well, as we all know, as we've been saying, getting a court to actually resolve issues on a subpoena is a very lengthy process. So increasing the cost for the executive branch to ignore a congressional request is what makes the accommodation process to work. So if the executive branch thinks, all right, we're going to lose this case and we're going to lose it not just for us, but for future types of information requests, if we had to pay a civil fine, if there was an appropriations sanction, if there was a possibility of criminal contempt using a private sector attorney, for example, instead of a US prosecutor, all of those things raise the cost for the executive branch to ignore the accommodations process. If those threats are there, they're more likely to negotiate, more likely to try to come to some agreement.
Thank you. Mr. Hunger, I have a related question for you. What steps do you think are important for a committee to take before going to court to make sure a subpoena it issues isn't ruled invalid?
Thank you, Mr. Chairman. So along the line, or in addition to the points that Ms. Bean made, which I agree with, I think the committee's hand is certainly going to be strengthened if it has engaged in a reasonable amount of negotiation with the executive branch in an attempt to obtain negotiated compliance with its demands, and has made sure that the scope of the information it's seeking and its relationship to the topic is appropriately focused, and it's clear that there is a legitimate, strong need for the information. And in those circumstances, the committee, by the time it gets to court, if it's actually forced to go to that stage, is going to be well positioned to demonstrate to the court why this step is essential and reasonable.
Thank you. Mr. Fernandez, your testimony identifies a crisis in effectiveness of congressional oversight of the executive branch in the last 4 decades. Can you give us some more context about how this crisis has developed in your opinion, and how it has been shaped, especially in the last 4 years?
Sure. Thank you so much for the question, Ranking Member Johnson, Chairman Johnson. I would say that one of the things that's most dispiriting is the fact that the accommodations process, which has formed the backbone of the vast majority of congressional oversight requests being fulfilled, has actually sort of been a process that's been admired in the possibility of an administration running the clock either on a presidency or any given House of Representatives. And as the possibility for the slow adjudication in the courts, making the running out of a clock possible, the accommodations process is broken down. Again, I think that the prospect, as Ms. Bean said, of quicker adjudication in the courts takes away this incentive that you saw quite frankly, in the last 4 decades, although you're right to point out in the last 4 years, the sheer number of flat rejections to comply with subpoenas seems to have increased. And one hopes that as a quicker adjudication of the courts becomes possible, that we'll return to some sense of normalcy with respect to good faith negotiations and accommodation.
Thank you. My time has expired, and then I will now turn to the gentleman from California, Mr. Issa, to be recognized for 5 minutes.
Thank you, Mr. Chairman, and I know my time will expire well before I get all my questions answered. I'm going to try and go through some bullet points. A couple of decades ago, President Richard Nixon was investigated for his involvement or possible knowledge of corrupt activity, basically Watergate. That process took less than 2 years. Is there any logical reason that the court should have have there been any changes in the court that would justify President Nixon leaving office less than 2 years after the Watergate break-in, and let's just say in the case of these last few cases, 3, 4, 5, even 7 years before final adjudication? Mr. Hunger, if you could opine on that quickly.
I think the answer is no. I think the intransigence of the executive branch has been what's changed over the last decades.
So it's fair to say that the executive branch has become more clever at finding delaying techniques. Would that be fair to say? And I just want to highlight one in particular. You mentioned in your opening statement the record of asking for a proffer of each and every element of an executive privilege or a rejection. Can you go over briefly, if you recall, during the process we went through in Fast and Furious, what was alleged to be executive privilege, and then what happened when the judge asked for that list to be produced?
It's a few years ago, but I'll do my best. So, well, first of all, the executive branch resisted for many months in even making an express claim of executive privilege, let alone producing a privilege log. And only when threatened with contempt did they finally even make the claim. And then when litigation was initiated, they still hadn't provided a privilege log. Ultimately, after a couple of years of litigation, they were finally required to produce one, and they then claimed that vast quantities of information were privileged, and that basically executive privilege extended to what have always been understood to be just traditional common law privileges, like the attorney-client privilege that Congress has always viewed itself as being empowered to reject. So their claim of executive privilege was incredibly sweeping.
Exactly, and just to refresh your memory, one of them was, of course, the theory that there's a clearance that we don't have to receive law enforcement sensitive information was one of the claims, not codified in any law. I want to just, for the record though, do you recall that more than 10,000 pages were delivered outside of privilege as soon as the log was requested? In other words, when Judge Jackson asked for the log and they finally had to produce it, we discovered that tens of thousands of pages of documents had no privilege, but in fact, when they had to make that evaluation, those were delivered. Does that refresh your memory?
That's exactly right. And even one of the unfortunate aspects of that case was that it took more than 2 years of litigation before the judge even ordered the Department of Justice to produce those unprivileged documents.
For the other witnesses, similar history all of you have had. If anyone wants to quickly opine on the privilege log being in this legislation and the time-sensitive nature of getting to that.
I'll just offer the comment
Yes.
that no attorney likes to produce a privilege log, because then it admits what documents you have and what the precise reason is for withholding it. And so I think the concept of requiring a privilege log and saying that if you don't produce it, you're waiving the privilege is one way to address that problem.
Thank you. And Mr. Chairman, If there's time for a second round, I look forward to it, but I yield back.
Thank you, Mr. Issa. And at this time, we will turn to the gentleman from New York, Mr. Nadler, for 5 minutes.
Well, thank you, Mr. Chairman. We've all been frustrated by the undue delays in enforcing the congressional subpoena power through the courts. Mr. Hunger, do you think we could dispense with all that if we were to revive the inherent contempt power, and if so, how?
Well, as I've suggested in my written testimony, I think, for instance, Congress could pass legislation that would authorize the imposition of fines in lieu of imprisonment, which I think everyone recognizes is a less than entirely salutary or desirable remedy in this day and age. And particularly in the case of federal officials, there would also be the possibility of imposing salary restrictions or reductions, that is, using the appropriations power to preclude the payment of salaries to federal officials who are obstructing congressional subpoenas and are found in inherent contempt of Congress by the House or the Senate. Those could at least be additional tools that might be effective in moving and advancing Congress's legitimate interests.
And none of those would be subjected to litigation?
Well, certainly you can. I would expect that, particularly the first time it was tried, that the contemnor would challenge that. But I think if it were done by legislation, if Congress, if the House or the Senate utilized appropriate procedures to ensure that the contemnor was allowed due process pursuant to the traditional standards for inherent contempt before a finding of contempt was made, that there would be strong arguments in favor of the validity of that approach.
Let me ask Mr. Garvey the same question about reviving the inherent contempt power.
Thank you, Mr. Chairman. Yeah, I think my thoughts are that the court has made quite clear that the inherent contempt power is one that Congress has. And, the possible benefits of bringing it back would be that Congress would no longer be relying on the executive branch to bring a criminal prosecution or the courts to adjudicate their subpoenas. Just one note about litigation that can still come out of the inherent contempt power is that if detained, the individual would still have the ability to bring a habeas corpus proceeding, which is what has happened in some of these historical examples.
But if not detained, but simply fined with large fines, there'd be no habeas corpus proceeding.
Yeah, I think that would be a different question. So yeah, if the reinvigoration of the power was not one of detention, but rather fines, then it's unlikely to have a habeas proceeding. But at the same time, if the fines were imposed and not paid, the question becomes, how do you enforce that fine, and is it through the courts? Because that's the concern, right? Is that we don't want to make changes to the subpoena enforcement framework so as to avoid the courts that ultimately end up back in the courts anyway.
It's sort of a catch-22. In recent years, we've seen the executive branch argue that Congress categorically cannot go to court to enforce its subpoenas. One version of that argument is that Congress can't sue the executive branch because there isn't a statute that says it can. Another version is that Congress doesn't have standing to sue. Mr. Fernandez and Mr. Hunger, I think we all have an intuition that these arguments are problematic, but I hope you can help explain what's wrong with them. What would happen if Congress suddenly couldn't enforce its subpoenas in federal court?
I think I'm sorry, I didn't know whether you wanted me to go first. I think if Congress is able to vindicate its interests in court, it again creates this incredible disincentive for any sort of compliance from the executive branch. Also, it then places this huge burden on these other mechanisms, all of which take a lot more political capital and raise the temperature of any given moment. The inherent contempt power that was referenced earlier before has not been used since 1935, and I think that's for a good purpose, at least in terms of the political optics of those sorts of things. Adjudication in the courts allows for Congress to vindicate its interests in a way that doesn't increase the political temperature, and in a way that hopefully allows for oversight to be seen in a way rooted firmly in both Constitution and our history.
Thank you. I want to hurry up on one thing because I want to get one more question in. We've heard the concern that passing legislation to establish a cause of action and expedited review could incorrectly be viewed as an implicit admission that Congress didn't have those rights in the first place. I think the argument is wrong, but it's something I think we need to take seriously. How can we ensure that any legislation or resolutions we pass to strengthen our investigatory powers aren't misconstrued or weakened or even extinguished, aren't misconstrued to weaken or even extinguish some of those powers? And Mr. Fernandez?
The time has expired, but the gentleman may answer the question.
Sure. I mean, I think expedited procedures can be set up with findings in the legislation, acknowledging that there are other routes, certainly preserving this, at least conversationally, but also there have been expedited pathways set up on other subject matters, as I mentioned in my testimony, which doesn't sort of exclude other pathways. It just simply says that when things are going through the courts, there's a quicker way to adjudicate it.
Thank you. As the chairman said, my time has expired and I yield back.
Thank you, Mr. Nadler. We will next hear from the gentleman from Ohio, Mr. Shabbat, for 5 minutes.
Thank you, Mr. Chairman, and thank you to all the witnesses for appearing this morning in this hearing. I've served on the Judiciary Committee for 25 years now. And during that time, I've seen impeachments. First President Clinton, I was one of the House managers, and then President Trump twice, and countless investigations, some of which resulted in the issuance of subpoenas to compel testimony of documents, depending on which party was in the majority in Congress and who was the president at the time. In recent years, specifically in the last 2 years and 5 months, it seems to me that the speedy and oftentimes hasty issuance of subpoenas have become much more prevalent due to political grandstanding. The issuance of a congressional subpoena not only comes at a financial cost to the federal government and to the taxpayers, of course, who ultimately foot the bill, but it also strains relationships between Congress and the executive branch. What's often lost in the process of an investigation is the informal negotiating between the two branches. In fact, the Supreme Court recognized this process and noted that, quote, each branch should take cognizance of an implicit constitutional mandate to seek optimal accommodation through a realistic evaluation of the needs of the conflicting branches in the particular facts situation, unquote. Sure, this give and take between the executive branch and Congress is time consuming and oftentimes complex. But I believe it's a much more efficient and productive process than attempting to score political points by dragging administration officials through a costly litigation process. And I think that's the case, whether it's Republicans or Democrats who are in the Congress or in the executive branch. Now a couple of questions. Mr. Hunger, with respect to congressional subpoenas, can you give us a quick overview of the accommodations process? And I know we've discussed it a little bit already this morning, what that process looks like, and probably more importantly, what it should look like between Congress and the executive branch, and provide some recent practical examples, if you would.
Sure. So, of course, at least in the vast majority of cases, Congress doesn't and shouldn't start the process by issuing a subpoena. It typically begins with a request for information to the executive branch, and there can be extended negotiations back and forth. Sometimes the executive branch, as it should, complies reasonably, but more often than not, in these days, there are substantial disagreements about the validity and scope of the request. And sometimes those can be resolved through negotiation. And as I said earlier, it's important for a committee to go through that process in good faith in the hope of resolving it. But the fact of the matter is, and this is increasingly a problem more recently, I think part because the executive branch realizes that it has the upper hand, when it knows that it's not likely to be forced to produce documents it doesn't want to produce, it has an incentive to refuse to produce those documents and to fail to engage in the negotiation process in good faith.
Thank you. What would you say are some of the pitfalls or negative consequences associated with Congress immediately or very soon in the process issuing a subpoena after not receiving everything in its initial request for information.
I mean, the courts have shown that they are reluctant. They really prefer not to get into disputes between the political branches, as we've seen, which I think explains part of the frustrations that have occurred in litigation. And if it appears to the court, rightly or wrongly, that there's been a rush to issue a subpoena and sue, they may be more reluctant to act expeditiously and may indeed try to encourage the parties to go back to the process of negotiation and compromise. So yes, it's important. It's important to give a good faith attempt to resolve the dispute through discussions before running to court.
Thank you. And before my time expires, I just, make the point, we've already mentioned the Fast and Furious and Attorney General Holder, but I do think that was a time where, unfortunately to the public, it was one of those things where why can't these people either ever work together or get it right? I think Congress looked oftentimes feckless. Even worse was that the administration, the Attorney General, looked guilty of something, trying to hide something. And the public was really noticing that. So that was a real black eye, I think, to the Congress and especially the Justice Department and how that all played out. And my time's expired, so I yield back.
I thank the gentleman from Ohio and will next recognize the gentleman from California, Mr. Liu, for 5 minutes.
Thank you, Chairman Johnson and Ranking Member Issa, for holding this important hearing. I'd like to follow up on Chairman Nadler's questions about inherent contempt, which is the power of Congress to impose consequences on both public and private sector witnesses who ignore congressional subpoenas. Ms. Bean, my first question is to you. Prior to World War II, Congress used this power a number of times. Is that correct?
Yes.
And just because Congress hasn't used this power in a while doesn't mean we don't have the power of inherent contempt. Is that right?
That's correct.
Okay. And one of these powers would be the ability of Congress to impose fines on witnesses who disregard congressional subpoenas, correct?
Well, I believe Congress has that authority, although it's never been used to impose civil fines.
Congress actually used even more powerful authority, which is, in fact, we put people in jail for ignoring congressional subpoenas. Is that correct?
Yes.
Okay. So thank you very much. Mr. Hunger, you are absolutely correct that the first time Congress reuses this power will likely be litigated. You're in private practice and you understand that incentives matter. And so right now, the current incentive, let's say with Don McGahn, is even as a private citizen, he can simply ignore the congressional subpoena. And at the end of the day, if the courts say he has to show up, he shows up and then he testifies. But if there was an actual consequence there where not only would he have to show up, but he might have to pay a fine of, let's say, $50,000 if he was wrong in the litigation, that would provide a pretty powerful incentive for someone to, in fact, not challenge in court and to show up. Is that correct?
I think that's correct. I mean, particularly for private subjects of congressional investigations, the cost and risk of litigating those issues would be substantial, and private parties generally try to avoid getting into that position in the first place.
Thank you. And Mr. Fernandez, I thought you made a good point about time. In terms of Congress, particularly the House of Representatives, we operate in 2-year cycles. That means the House could flip, chairmanships could change. So if a witness is able to delay a congressional subpoena more than 2 years, and often it'll be less than 2 years because Congress usually doesn't issue a subpoena on day one of Congress. If they could simply delay it for, let's say, a year and a half, oftentimes circumstances could change so radically that essentially the congressional subpoena becomes meaningless. Isn't that correct, Mr. Fernandez?
That's exactly correct, Congressman.
So let me take my remaining time to just offer some thoughts. Both Democratic and Republican administrations have ignored congressional subpoenas. And it is wrong when Republicans do it. It's wrong when Democrats do it. And we saw, for example, that when a Democratic administration delayed for more than 2 years, having a witness show up, that the Republicans didn't fix that when the Republicans were in control of the House and the Senate. Let's not make that mistake again. Democrats control the House and the Senate. Just because we believe we have a good president doesn't mean that we're going to have future presidents that won't do exactly what the former president did and run roughshod over the Constitution and Congress and the American people. We need to rein in the executive branch. And I just want to know that under the Department of Justice, under Merrick Garland's leadership, it has taken the exact same view of maximizing presidential power to the point of absurdity. It is refusing to release the Barr memo. It is refusing to even say that the DC court panel case that said congressional subpoenas are meaningless was wrongly decided. In fact, it supports that decision. And then recently, the Department of Justice says it is going to act as the former president's private attorneys to defend the defamation lawsuit by Ms. Carroll. So this is the same exact Department of Justice that has been maximizing presidential power to the great harm of our separation of powers, that is shredding the way the framers set up our Constitution. And we as a Congress need to rein in the executive branch. If we don't pass any reforms to try to rein in the executive branch, then shame on us. I yield back.
Thank you, Mr. Liu. I'll next recognize the gentleman from Wisconsin, Mr. Tiffany, for 5 minutes.
Oh, thank you, Mr. Chairman. I have a question for Mr. Hunger to start with. The Supreme Court in Quinn versus United States held that there are certain limitations on Congress's subpoena authority. For example, the subpoena needs to serve a valid legislative purpose. What exactly does that mean?
Well, a valid legislative purpose in the views of the House and the Supreme Court has been long understood to be an extremely sweeping concept, because anything that Congress may or could legislate on is within Congress's legitimate purpose to investigate, and any sort of official misconduct or simply the implementation of congressional legislation and appropriations is also within the legitimate scope of congressional investigations, and therefore there's a legitimate legislative purpose in investigating those topics as well.
Could you give me an example of a subpoena that may not serve a valid legislative purpose? Give me an example.
Well, the court has suggested that investigations, for instance, that are aimed purely at exposing private misconduct would be beyond the scope, or investigations that are essentially trying to take the place of a judicial proceeding, a function of the other branch of government, would be inappropriate. But it's an extremely broad category of investigations that Congress is permitted to implement.
Thank you, Mr. Hunger. I'm going to yield back the balance of my time to the ranking member, Mr. Issa.
I thank the gentleman. I appreciate that. I'm going to follow up exactly where you left off. Let's go through some hypothetical examples, because I think it is important. Mr. Hunger, or for each of the panelists, would it be fair to say that investigating the actions of a president or some other official prior to, after they're in office, for the actions in their private life before they came to office, and I'll use the example of Whitewater and President Clinton, is it fair to say that investigating, and I'm trying to be partisan on both sides here, it's fair to say that that would be something that after an election, trying to adjudicate something that you claim the president did wrong before he came would be outside a legislative purpose? Is that one example?
Well, I would hesitate to say that's outside legislative purpose, but I would say it's further removed, certainly further removed from the core of legislative purpose, and therefore you're likely to see more resistance in the courts if you're trying to pursue such an investigation. But I mean, again, if it's a legitimate, it sort of depends on the precise justification being offered, as we've seen from the Supreme Court in the Mazars case. If there's a legitimate need for Congress to get the information in order to legislate, for example, the mere fact that it was conduct prior to service in office doesn't preclude the investigation.
Okay. And on another note, there was some discussion about whether an investigation is partisan or not. Most investigations in the House historically have had one party or the other leading it, normally the party in the majority, correct?
Yes.
So it's fair to say that that partisan may not be the test. Let's go through a couple of recent examples very quickly. In the case of whether or not the U.S. attorneys were fired properly by George W. Bush, in that case, then John Boehner led a walkout of more than 100 members of the House rather than voting for it. Did that diminish the legitimate right of the Congress to know whether or not those firings were for some nefarious purpose?
No.
And in the case of Fast and Furious, when you had a letter sent to Senator Grassley, which turned out to not be true, the investigation of why and how the Department of Justice clearly and knowingly lied to a U.S. senator does it matter whether that's partisan in who's bringing it?
No.
And lastly, for all the panelists, is there a structure you can see, and I do see one potentially, where we could extend our power well past 2 years of subpoenas by having an enduring document, just as we do have things appropriate over multiple Congresses? Anyone see that that's not that there's no remedy for that? It's not in the current legislation. Well, that one will be continued. I hope that all of you will ponder that, because I would like to set up a structure in any new legislation that gives us the ability not to have to rely on the next chairman for something that's ongoing, because I do believe that is part of what presidencies often rely on. And with that, thank you, Mr. Chairman. I yield back.
Thank you. Next to be recognized will be the gentleman from Arizona, Mr. Stanton, for 5 minutes.
Good morning, Mr. Chairman, members of the committee, and our esteemed panel. I want to thank each of you for spending your day with us today and taking our questions on these important issues. As each of you know, a defining characteristic of our system of government is the principle of checks and balances. It's not a new or novel idea. It's one that's outlined in our Constitution. It's discussed thoughtfully in James Madison's Federalist Papers, and of course, it's been litigated before the Supreme Court. And as part of our system of checks and balances, Congress, through committees and subcommittees like this one, has the power of inquiry, the power of oversight over the executive branch. What is new, though, at least more frequent it would seem, are the executive branch's attempts to effectively stonewall the Congress when it moves to investigate executive action and refusing to comply with congressional subpoenas. We've heard testimony today regarding 4 historical examples occurring under 4 different presidents from both political parties, which has shown us that Congress must engage our third branch of government to enforce congressional subpoenas civilly through the courts. It's a time-consuming task that impedes and delays appropriate and necessary oversight. But I am heartened today to see that there is bipartisan engagement we have on this important issue, and I look forward to working with my colleagues on this committee to advance solutions that will allow Congress to better execute our constitutional duties. With that, I'll turn to some questions. My first is for 3 of the panelists. There exists what I would call friendly criticisms of Congress focusing on going to court more to enforce its subpoenas. As I understand this critique, the argument is that if Congress shouldn't try to change the civil enforcement process because federal courts are simply inhospitable to congressional subpoena enforcement actions. What would you say to this criticism that our cases will never move quickly enough, even if we pass a statute requiring expedited review? How about Mr. Fernandez? We'll start with you, and then also ask Ms. Bean and Mr. Hunger.
Thank you, Congressman. While there's no guarantee of how quick an adjudication can happen, at least the way these expedited review mechanisms have happened in other subject matters. So for instance, apportionment cases, incredibly important congressional apportionment cases, we have seen that an expedited mechanism provides the prospect of a quicker adjudication. Now, in that statutory scheme and in any expedited statutory scheme, there's no number of day requirement or no strict requirement of how long an adjudication can happen. But I think that there's some optimism that the courts can, if given the necessary urge from Congress, expedite consideration and adjudication of these disputes.
Thank you. Either Ms. Bean or Mr. Hunger?
I'll just say that I think the courts would comply with the law. If there was a law that required them to have a duty to expedite and they were required to issue procedural rules that put that into effect, I think the courts would comply with the law.
I agree, and I would only add that the proposed legislation that would allow the filing of a case in a 3-judge district court and then direct appeal to the Supreme Court would necessarily speed things up, because it would skip a layer that we currently have to go through in getting final resolution.
All right, thank you. Ms. Bean, I have a follow-up for you. In your written testimony, you advocate for Congress to establish a bicameral, bipartisan congressional counterpart to the Department of Justice's Office of Legal Counsel. So I would like to elaborate on that. It's a really interesting idea. How would you propose such a body be organized, and how that legal opinions drafted by the legislative branch might strengthen Congress's case for enforcement in court?
Well, right now, the Department of Justice cites its own legal opinions all the time in court as if they were judicial opinions. And they have a very persuasive impact. And Congress has nothing similar to rely on. I think if Congress wanted to set up a counterpart, it has to be bipartisan, really, truly bipartisan. And I think it would be better if it were bicameral as well. It doesn't have to be. And you could just have the Senate Legal Counsel and the House General Counsel form a body. Some people talk about having CRS do it. I don't think that's as good an idea, because they don't litigate in the courts and don't understand the law in the same way as the people who have to litigate. But they could address a very small number of issues that are very bipartisan. For example, there is no absolute immunity to congressional subpoenas for senior White House or presidential aides. I think both parties could agree on that. Executive privilege, the way to assert it, you have to have a written assertion by the president. You have to have a privilege log or it's waived. If we had those kinds of bipartisan and especially bicameral opinions, I think would be very influential in the court. It's worked for the executive branch, and it could work for Congress as well.
Those are great
and you
ideas.
don't need a
Thank you.
law either.
Yeah, great idea. Thank you so much for that testimony. I yield back.
Thank you. I now recognize the gentleman from Texas, Judge Gomet, for 5 minutes.
Thank you, Mr. Chairman. Appreciate this hearing and this time. This is something that we ought to be working diligently together to resolve, because we have not done a good job of oversight of some parts, especially Intel. I know some areas are outside our jurisdiction, but the Justice Department. And Mr. Hunger, I was going to ask, you're familiar with what happened in Fast and Furious and the effort of Congress to get information about that, right?
Yes.
And that was such a frustrating time. To me, it wouldn't have mattered what administration was in office, but to actively work to get over 2,000 weapons in the hands of the drug cartels just seemed to be something bordering on criminal that we needed to really get to the bottom of, and we never did. And of course, the Attorney General was held in contempt, but still, as others have noted, there wasn't any firm decision until he was out of office, and it was really too late. So I'm curious, based on what you have seen and thought about in analyzing that, what would have been the best way to go about getting the documentation we never got, to give us specifics about how that whole thing came about, who was responsible, why they did what they did? What would have been a better way to go about getting that information?
Well, I think in that case, as others have suggested, the biggest problem was simply the inordinate delays that occurred in the district court, where it took literally 3.5 years before the district judge ruled on the merits of the committee's claims, which of course is completely unacceptable given the time frame of congressional investigation.
But how do we improve on that? There's got to be a way.
The proposal is to mandate expedited proceedings in the district court as well as the courts of appeals. One of the bills that was proposed, I think, last session would have also authorized essentially appellate going to the Court of Appeals for a prompt ruling, compelling the district court to move quickly if the district court fails to do so. I think that's a good idea as well.
But what kind of language would you use to do that?
An obligation on each level of the federal judiciary to expedite to the greatest extent possible these proceedings, a provision enabling the committee to go to—
Mr. Hunger, you're a good lawyer. You know, when it's when you leave back doors open, like to the greatest extent possible, you will have federal judges that say, that's just not possible. I've got these other cases that I think are more important, and I'm going to deal with those, and I'll get to the other as soon as I deem it's possible. I'm wondering if there need to be language that said the court had to give it priority over all others cases that are not life-threatening, if we needed to be more specific in order to get that case taken up.
That might be helpful. I mean, I think in fairness, most federal district judges in these cases have proceeded relatively quickly, 1 month, 4 months, 5 months, things like that. The Fast and Furious case was a real aberration in that regard. The appellate process is what takes so long, and allowing for direct review in the Supreme Court would help short circuit that.
Well, do you agree with Clarence Thomas's statement? Congress has no power to issue a legislative subpoena for private, non-official documents, whether they belong to the president or not.
No, and the Supreme Court doesn't seem to either.
Well, I understand that, but so how far do you think we should be able to go delving into non-official private documents?
Well, again, there has to be a legitimate legislative purpose, and certainly the Supreme Court has rightly recognized that merely trying to expose private individuals is not a legitimate legislative purpose. But there are certainly going to be circumstances in which, for instance, the Backpage investigation by the Senate a few years ago, where private entities have information that the Congress needs in order to address and legislate responsibly about a problem.
I see my time's expiring. I yield back.
Thank you, Mr. Coleman. We will next hear from the gentle lady from California, Ms. Lofgren, for 5 minutes.
Thank you very much, Mr. Chairman. This has been an interesting and important hearing, and I was listening carefully to my colleague, Mr. Shabbat. He and I were elected the same year, 1995, so we've been through a lot of these fights in the Judiciary Committee and in the Congress, and thinking about the legitimate scope of an inquiry, a legitimate legislative purpose. To some extent, it's in the eyes of the beholder. When Republicans sought information from Democratic administrations, Democrats in the House might not think it was legitimate. And when Democrats did the same to a Republican president, Republicans might not feel it's legitimate. But in the end, what we've seen is a diminishment of congressional authority relative to executive authority. And I think that's not what the founders had in mind. And if we are able to put our partisan views to one side and think about strengthening the legislative branch, that we will make progress. I'm wondering this. We've had several suggestions made here today. I love the idea of having a countervailing Office of Legal Counsel. I've thought that for a long time. It is absolutely bizarre that the administration cites itself as an authority in court, and that somehow that is given some credence by the judiciary. So we ought to have a countervailing provision. I think the expedited civil review is something that we need to pursue. The definition of what actually uh, counts as privilege, and the requirement that it be detailed through a privilege log detailed either in person or in writing, all of those things, as well as a revitalization of inherent contempt, especially looking at the civil fine. So here's two questions. One, if we did all of the above, would the element of having alternatives be viewed as by a court as a way to defeat any of the other alternatives? Because anything we do is going to be litigated, at least initially. And here's the second question for each of the witnesses. You know, we have had oversight over the years. I remember being on the staff during the impeachment of Richard Nixon. We didn't have any White House officials refuse to come in and be interviewed by the Judiciary Committee at that time. Now we see administrative officials just refusing to even respond. So how did it come to this point? Those two questions, and starting with you, Mr. Fernandez, and Mr. Hunger and Ms. Bean.
Sure. So thanks. I'd like to take the first question first. I don't think that the existence of multiple options necessarily weakens any one given option. I do think when you come before the courts, for any particular judge or court that is hesitant to get into an interbranch dispute, you could see the kinds of subconscious punting to other mechanisms. And certainly you've seen courts pull away at times. You saw this in the litigation of the Myers controversy, of saying, well, there's an accommodations process, we're going to hold off until that's exhausted. So it's certainly possible that it could be used by any given court as a way of sort of punting, and because they're hesitant to get involved in interbranch disputes. But I don't think that simply having those options weakens any one of them.
Ms. Bean and then Mr. Hunger. I'm going to run out of time, I think, before my second question gets answered.
Well, I was just going to say that because most of these disputes are resolved in the accommodations process anyway, having these alternatives raises the cost for the executive branch to just say, I'm not going to even respond. So I think that that's important thing to think about. It's not just about courts. I agree with Mr. Fernandez that a court is not going to say, because you have other alternatives, I'm not going to go forward here, other than there's some pressure that way. But if they're going to decide, they're going to decide. How did we get to this point? We got to this point because we can't enforce the subpoenas. And so every time a subpoena is not enforced, the executive branch is emboldened to say, I'm not going to engage in the accommodations process. So I think it's sort of a self-fulfilling prophecy there.
My time has expired, but I wonder, Mr. Chairman, if Mr. Hunger disagrees with the other speakers, if he could at least indicate that.
I don't disagree. I think there's a risk that courts might do that, but they shouldn't. And in general, I don't think they would rely on the contempt power as a means for not granting relief.
My time has expired, Mr. Chairman. I yield back.
Thank you. I will now recognize Mr. Massey, the gentleman from Kentucky, for 5 minutes.
Thank you, Mr. Chairman. Just quickly following up on Mr. Gomert's point, if Congress could subpoena private and corporate records, that sets up a dangerous asymmetry, because we enjoy the speech and debate clause, and our own documents aren't FOIAble from those private citizens. So I'd be a little bit worried about that. Just quickly, I once had breakfast with Antonin Scalia and a dozen other congressmen, and the Republican congressmen were complaining about the balance of power and how the courts needed to step in and restore the balance of power between the executive and legislative branches. And this was in the context of Eric Holder not complying with requests for witnesses or documents. And Scalia said, well, you have all the power you need right there in the Constitution. And one of our colleagues said, well, impeachment's so unwieldy. And Scalia laughed and he said, I'm not talking about impeachment. You fund all of the things you complain about. Now, obviously, the lack of funding can't directly compel documents to appear or witnesses. But I think if we would just cut their funding 10%, you'd see those documents delivered the very next day. So anyways, with that, I don't really have questions for the witnesses, and I want to yield the balance of my time to the ranking member who's over the target and right on point on this issue, Mr. Issa.
Thank you. And my memory of Justice Scalia and those that his pushing back on our request is still very vivid. So let's follow that up for each of the witnesses. A powerful tool would be, in fact, to deny the executive branch individuals, or for that matter, private individuals, the ability to use federal funds to defend themselves. And I'd like you to opine on the value of that. Conversely, the explicit ability to use federal funds for voluntary compliance. If we were to set that up in the law very specifically, no appropriated funds may be used to fight, but of course, appropriated funds can be used for all voluntary cooperation. Would that be a powerful tool to both give and to take? I'll start with Ms. Bean.
I think it would be a very powerful additional tool. And I thought Mr. Hunger's suggestions about also making it possible to take away somebody's salary, I think is a pretty powerful tool as well. Using the appropriations process in general is very difficult because it doesn't coincide at the time that you need to get documents. You have to set up mechanisms that were not dependent upon a particular appropriation cycle. But your suggestions aren't dependent upon the appropriation cycle. So I think it's a very interesting way to go.
Mr. Hunger, you've watched a few of these in actual cases. The amount spent by the executive branch, let's just say both in Fast and Furious and in the Harriet Miers case and the firing of the U.S. attorneys, do you think that the court would invalidate that, or do you think it would be held constitutional for us to limit some aspects of their ability to defend, outside of voluntary cooperation?
I think that's a hard question. And one thing I suspect a court, if faced with a situation in which the Justice Department said we can't litigate this because we have no funds, a court might be unwilling to entertain the dispute without, perhaps appointing an amicus curiae counsel essentially to represent the government's interests, which raises its own difficult challenges. So I'm not sure how that would come out. I think the courts would be very uncomfortable with being asked to litigate enforcement actions where one side has its hands tied behind its back. But certainly it would create problems for the Justice Department, which might make them a little less willing to go to litigation.
In most cases, when I've done depositions, I've noticed that counsel typically will have the executive branch counsel and private counsel there. As a matter of fact, I almost never remember a witness not bringing their personal counsel in addition to the government counsel. Is that more or less your memory?
Generally speaking, yes.
So if we're trying to structure something to a certain extent, we're really just eliminating the ability to use both. And I see my time, or Mr. Massey's time, has expired, and I yield back, and I thank the chairman and Mr. Massey.
Thank you. And I find it deeply disturbing, but not surprising, that Justice Scalia would be caught up in a secret private meeting with legislators, with action before the courts, likely to end up before his own court. And he's dispensing political and perhaps legal advice to those Congress people. I find it deeply disturbing, but
let me defend him real quickly. He refused to opine on the exact case.
Just the mere fact of meeting and having a private breakfast is deeply disturbing. And with that, I will yield to the gentleman from Tennessee, Mr. Cohen, for 5 minutes.
Thank you, Mr. Chairman. Mr. Garvey, in your testimony, you talked about criminal contempt. And I know there have been some questions about criminal contempt. What do you think? As I understand it, it was said that the House didn't pass due process as the Senate had to have criminal contempt, and we had to pass a statute. Is that your understanding, that we need to pass a statute laying out due process for criminal contempt to be effectuated on a House subpoena?
If I understand your question correctly, Congressman, are you talking about criminal contempt or civil enforcement of subpoenas?
Criminal contempt.
Yeah, so, criminal contempt is actually a pretty basic and straightforward process, and the statutory provisions already lay out that process. The committee votes, the House votes, it's forwarded to the U.S. Attorney, and the statute says that it shall be the duty of that U.S. Attorney to forward it to a grand jury. And at that point, the prosecution would proceed under the control of the executive branch.
Well, maybe I'm remembering or failing to remember something, but I thought we wanted to use criminal contempt to enforce our subpoenas. We were told that it was a 1920-something case, and the Senate had acted and laid out some rules, and we had not in the House laid out any rules, so that we needed to do that. And I thought it was in the Rules Committee, and it kind of got stuck there, but I'm not sure. You can't put any more meat on the bones.
I don't know, Congressman. I mean, due process comes up in some of the other contexts when we're talking about inherent contempt and reviving inherent contempt. It's clear that Congress would have to provide due process.
Right. And is the House not provided that in inherent contempt? Is there something we need to do?
So there are no existing rules that lay that out. The House could choose to proactively establish a process, and that's something that actually Congressman Liu's bill would do. So it would, exactly show what the process would look like and what process would be provided to the contemnor. That's an option. It doesn't have to work that way. I mean, tomorrow the House could pass a inherent contempt resolution calling or authorizing the sergeant at arms to detain someone, and the House could just go forward with that resolution after resolution, sort of ad hocly establishing the procedures for that proceeding.
Could I?
So are you saying? Please, yes, Ms. Bean.
I think you might be, one of the issues with criminal contempt, inherent criminal contempt, is we can't enforce it. And with respect to the executive branch in particular, the Justice Department, despite the law, says, I'm not going to comply with the law. I'm not going to prosecute against an executive branch official because I have prosecutorial discretion. So one of the solutions to that is Congress could hire a private sector attorney, a former prosecutor, to prosecute these cases. And you could do that either through having a statute, or I think you could even do it through House rules and see if the court would accept that. So criminal contempt has become unavailable because the Department of Justice simply won't use it when it comes to an executive branch official. So you could have a private sector person do it.
Thank you, Bean. The inherent contempt, there's no reason not to pass Mr. Liu's bill, then, is there?
I'd have to look at that bill. I can't remember all of the provisions in it, but I think his mostly has to do with civil fines, which is different than criminal contempt. I don't think his bill actually creates an authority, if you need to do it in statute, to hire a private sector attorney to do a criminal contempt case in court.
Thank you. Let me ask Ms. Lochran asked a question about kind of when did this all go so far off the cliff? And when was it, do you believe, Ms. Bean, or Mr. Garvey, you might have the history of it just as well, if better, I don't know, that we started to get into all these problems? When did we lose collegiality and our normal function and get to be so averse? We
had decades of time where there was not a court case filed. And although people were unhappy with some things, it's only in the last 10, 12 years that we've started to see these court cases, because as Mr. Hunger said, it isn't that the courts have changed, it's that the executive branch is becoming increasingly disrespectful of the accommodations process.
Well, you said 10 to 12 years, that would take it back to Mr. Obama. What Mr. Bush?
Well, Fast and Furious was really, I think, a watershed moment when the administration just said, we're just not going to cooperate. And you went through this, 7-year journey through the courts.
How was Harriet Meyer's case? Was that wasn't really exactly hunky-dory, was it?
That's true, but
gentleman-
you did get a pretty
and the
quick
gentleman-
district court decision.
The gentleman's time has expired, but the witness may complete her answer to the question.
I saw Mr. Hunger nodding as well, that I thought in the Myers case, you got a pretty quick decision from the district court.
Time has expired, and I will now move to the gentleman from Wisconsin, Mr. Fitzgerald, for 5 minutes.
Thank you, Mr. Chair. Kind of on the heels of what Congressman Cohen just brought up, the criminal contempt question for Mr. Hunger and then for Ms. Bean, I guess. What are some of the pitfalls or consequences associated with Congress immediately issuing subpoenas rather than exhausting some of the other things that might be available to us? I mean, anybody that, whether they're private or public, would suddenly be find themselves being served a congressional subpoena. I mean, I would think that everyone would advise, guess what? You need an attorney, and you need an attorney now. So it's I don't want to lose the gravity of what a congressional subpoena is, and it seems to be, today in our hearing, it's kind of be diminished by the idea that people aren't complying, but there's still a lot there, isn't there, Mr. Hunger or Ms. Bean?
I certainly agree that, except perhaps in rare circumstances, the way Congress normally proceeds, which is to ask for the information, not demanding it, is appropriate. And as I said, courts are more likely to be willing to act expeditiously to enforce subpoenas when it's clear that the committee has gone through an appropriate effort to obtain the information voluntarily and to negotiate a reasonable solution, and has been unable to do so. But I mean, nothing in the Constitution precludes the issuance of a subpoena from day one. It's just not necessarily the most effective or appropriate way to proceed.
The only thing I would add is I agree with that completely, and we would always ask before issuing a subpoena. There are rare circumstances if you're trying to get information from a bank, if you're trying to follow the money. Banks do require subpoenas from the very beginning. You can't just ask them to give you somebody's banking records. They won't do it. You have to have a subpoena.
Very good. Just one other thing. In Committee on the Judiciary versus Myers, the court rejected the idea that executive privilege absolutely shields senior White House staff from compliance with congressional subpoenas. Are there any unique considerations for Congress's ability to use civil enforcement in the context of executive branch officials? And I would also open that up to Mr. Fernandez and Mr. Garvey.
I would just say, Congressman, that whenever we're talking about lawsuits filed by Congress against the executive branch, so when we're talking about subpoenas issued to executive branch officials, there are unique judicial considerations, and they're the considerations that often are what cause these cases to take so long, and they're the justiciability considerations. So it's things like standing, cause of action, jurisdiction, separation of powers. These are all difficult, thorny questions. And it seems, especially in the appeals, those are the specific issues that have been delaying a lot of these cases.
Very good. Mr. Fernandez, do you have a comment on that?
Yeah, no, I agree with what Mr. Garvey said. I don't have anything additional to offer.
Very good. Mr. Chair, I don't know if the ranking member has any other questions. Mr. Issa, I would yield to Mr. Issa.
Well, I'm sure Mr. Issa has some more questions.
Well, I appreciate it. Thank you for yielding, and I'll be brief. The nature of this this bipartisan discussion today seems to be very good, and the options we're being given seem to be very good. But the one question I would have for our witnesses is, in my opening statement, I talked about the speed of the current FOIA law. And often the executive branch essentially tells us they're treating us as FOIA. But over the last few years, the speed with which Freedom of Information Act request, and will include the last administration and the two before it, has often been faster than Congress. Can any of you explain why an ordinary FOIA request can often get into court before a judge, and a judge ordered discovery to be turned over faster than in a congressional investigation.
I think part of the reason is that the law is well established in that area, and the courts view themselves as having an obligation to proceed with reasonable speed in order to effectuate the public interest. And the Justice Department doesn't have the whole panoply of arguments that they throw up every time the Congress goes to court against them, because the issues have been resolved. It's really just a fight about what is or isn't privileged under the FOIA statute. So I think the legislation that has been discussed here today would help by, for instance, establishing that it's clear there is a cause of action, which should be clear anyway, but the Justice Department continues to deny. It would help eliminate some of the obstacles that prevent the courts from proceeding as expeditiously as they do in the FOIA context.
So in closing, it would be fair to say that we should take the successes of FOIA and incorporate it in any legislation that we were to move forward with.
Yes.
The time has expired and the gentleman may answer the question, the witness.
I think he did. Thank you, Mr. Chairman.
Thank you. And with that, we will go now to the gentleman from New York, Mr. Jones, for 5 minutes.
Thank you, Mr. Chairman, and thank you to each of our distinguished witnesses for joining us this morning. We are still in the morning time. And look, I'm really excited about what is yet again a bipartisan discussion about how to solve weird issues. My great thanks to everyone on the full Judiciary Committee who has advanced legislative proposals for actually restoring congressional oversight authority over the past several years, including Representatives Dean, Liu, and Ranking Member Issa, excuse me. I'm looking forward to working with all of you. I just want to acknowledge that the American people have the right to know what our government does. In fact, our democracy depends on it. But our right to know is only as real as our power to bring the truth to light. And over the last several decades, presidents of both parties have exposed that Congress does not have the power we need to uncover the truth. When a congressional committee like ours wants to know what the executive branch is up to, we can ask an official to testify. If they refuse, we can issue a subpoena. A subpoena is a legal order. It is not optional. So in principle, when we issue a subpoena, the official is supposed to show up and answer our questions. But in practice, refusal has become all too commonplace. Say we subpoena someone and the president orders that person not to show up. Maybe the president did something wrong and doesn't want us to hear from a key witness. I know it's hard to imagine, right? But let's just suppose. In that all too common scenario, we are stuck with 4 inadequate options. We can withhold funding or refuse to approve nominations. But then the American people pay the price for the president's obstruction. We can threaten to use our inherent authority to arrest someone for contempt. But they will call our bluff, as we've seen. Congress has not used that power in over 80 years, as we've heard. We can ask federal prosecutors to bring criminal charges. But those prosecutors work for the very administration we would be asking them to prosecute, as we've also heard today. And the conflict of interest speaks for itself in that regard. Finally, we can take defiant officials to court the way that this committee just did in the McGahn case. But the president can delay a civil enforcement case for years, running out the clock. The Trump administration perfected this playbook, obstructing our inquiries over 30 times. But as my esteemed colleague, Representative Liu, underscored earlier in this hearing, the problem is bipartisan, and the solution should be too. We should not have to ask the president's permission to exercise our constitutional authority. We need to prepare for the worst, not assume the best, to design our democracy to be resilient to its greatest threats, rather than dependent on norms of good faith and cooperation between the branches that we can no longer count on. So the time for a bipartisan effort and bipartisan legislation to reinvigorate our oversight powers is now in this Congress, while we have a president committed to the Constitution, the rule of law, and our democracy. So Ms. Bean, in your written testimony, you suggested that one way we could expedite judicial review of civil enforcement actions would be to enact a statute directing courts to apply a deferential standard of review to congressional subpoenas. Could you say more about how such a statute would work and how it would help address this problem?
So I was talking about that in the context of having civil fines. If Congress imposed a civil fine, you could also specify the standard of review by the courts. And for example, you could use say the only way you can overturn a civil fine is if there's an abuse of discretion. That's a commonly understood standard out there, and that's one that you could specify. Otherwise, the courts would go through a very long process trying to decide what the correct standard of review is. You could also bar a de novo review of any factual finding. In other words, a court should not re-litigate the facts. They should accept the facts as Congress found them. That would be another way that you could expedite judicial review by taking those things off the table. You decide what the standard of review is, and you'd say fact finding, you have to accept what the Congress has found, again, unless there's an abuse of discretion.
Thank you for that. You also mentioned authorizing Congress to file a civil enforcement action directly in the DC Circuit Court of Appeals. Could you walk us through how that would help?
Well, this was an idea in some other legislation out there. They suggested having a 3-judge panel on the district court and then going directly from there to the Supreme Court, which has been done in other contexts. Another way you could do it is if Congress decides that they're going to have a subpoena, you could have because Congress can constitutionally fashion the jurisdiction of the courts, you could just specify that any dispute over subpoena goes directly to the appellate court and then from there to the Supreme Court. So it's just an alternate way of thinking about it.
Thank you, and thank you, Mr. Chairman. I yield back.
I'm sorry, I was on mute. We will now resort to the gentleman from Oregon, Mr. Bentz, for 5 minutes.
Thank you, Mr. Chair, and thanks to all the witnesses for an excellent hearing. And the question I was going to ask was just asked by the last congressman, and it goes right to the question of how best to design our courts review system to be more expeditious. And I think that area has been exhausted. And with that, Mr. Chairman, I'll yield back. I'll yield to Mr. Issa if he would like. And if not, I yield back to the chair.
No, I would like, thank you very much. Everyone's being very generous. Ms. Bean, I want to follow up with something I think originated from you. Correct me if I'm wrong. As we look at the idea that the executive branch opines, Department of Justice, on their own ideas, rulings, standards, precedences, and that we don't have a countering part, would you, because the House and the Senate always has a difficulty coming together, would you suggest that the Senate have its own deliberative body, the House have its own deliberate body, but that in fact we have a bicameral body that would deal at, if you will, the 10,000-foot level and hopefully codify House and Senate rules and procedures so that there was some similarity between the two, because currently, as you know, the Senate subpoenas are dealt with slightly differently than the House subpoenas.
Well, I think you can go either way. The House and the Senate could have their separate ways of issuing official legal opinions on particular issues, but I think it would be even more powerful in a court if it was bicameral. And it doesn't have, it could be, you have people litigating in the House and litigating in the Senate. You could select a small number of issues that both sets of litigators know is a problem and get them together and use their best judgment to come out with a single opinion. So I think that's the best way to go if you're going to influence the court. But again, you could have one process in the House and one process in the Senate.
But you do believe that a bicameral bringing together of these two standards, the House and the Senate chairman and ranking members, often the rules of these two bodies are inherently going to be different. But just to reiterate, I believe you're saying appropriately that if we were to form a bicameral group to harmonize at least some of these opinions, that would be the most powerful.
Yes, and I'm not suggesting that they would issue procedural rules for any committees. I'm just saying it would mostly be on third parties, on the executive branch or private parties that are contesting congressional oversight, to have some general opinions about their constitutional obligations to cooperate with Congress.
And I just want to follow up quickly for the record, because there's always a discussion about how, and I think Mr. Massey brought this up, Congress will subpoena a private individual or a bank record and so on. Isn't it true that essentially the executive branch has a number of tools, including when they issue a subpoena, you do have to compel. If they go to the FISA court, they can essentially use material not even necessarily available to the defendant when they receive a subpoena or are subject to a warrant. Aren't those tools that in fact Congress doesn't have, that certainly in the balance of power Congress should have something close to the equivalent when they're investigating the executive branch?
As I understand your question, it's should Congress have the ability to use subpoenas to get classified information? Is that what you're asking me?
I am, because as you know, the executive branch has no shortage of the ability to compel that, including from Congress, notwithstanding speech and debate.
Yes, I think Congress should have the ability to subpoena or compel information, including classified information.
And lastly, the executive branch, in several cases, but we'll just use William Jefferson, has not historically felt that speech and debate prohibited them from using their subpoena and warrant capability for criminal investigations of members of Congress, including entering the House to take computer records and the like.
I'm not an expert in that area. Perhaps Mr. Hunger knows more, but I know that there have been cases litigating those issues.
Yeah. Mr. Unger, although there's an agreement, has there been any statute that has updated the ability to limit the executive branch when they enforce warrants and subpoenas since the days of William Jefferson?
And the time has expired, but the gentleman can answer the question quickly.
Thank you. I don't believe there is any such statute, and that was an area of recurring concern for the House when I was a general counsel, and I suspect those problems still remain today.
Thank you. Thank you, Mr. Chairman.
Thank you. And now we come to a part of the hearing where we've all been waiting so anxiously for. It is the 5 minutes for the gentle lady from North Carolina, Ms. Ross. You may proceed.
Well, thank you very much, Mr. Chairman and Ranking Member. Such an important hearing and really good questions. I just have a few, and they're pretty technical questions, but I think they're important because so many of these issues have been going to the courts. My first question is for Mr. Garvey. In Trump versus Mazars, the Supreme Court said in dicta that recipients have long been understood to retain common law privileges with respect to certain materials, such as attorney-client communications. And the opinion cited a number of CRS reports to support that statement. Is it your understanding that the CRS reports that the court cited actually support this dicta?
Thanks for that question, Congresswoman. The reports that were cited were from 2003, which was before I arrived here at CRS, but I have looked at that report, and I would say no, I don't think the report supports that proposition. Congress's position has long been that it is not bound by common law privileges. Instead, Congress has said that it's at the discretion of the committee chair as to whether or not to accept that type of a privilege. And in fact, there are multiple House committees who have that specifically in their committee rules. So, I think that line in Mazars is an odd one, and it's one that's been subject to a lot of criticism.
Okay. And Ms. Bean, does the court's dicta square with your experience in congressional investigations?
It does not. For my entire 30 years, my understanding was that the Congress is not bound by common law privileges. And part of the reason why is our oversight does not have to do with personal liability, criminal or civil. We're gathering information for policy purposes, for legislative purposes, and therefore that's a reason why those common law privileges that were developed in the courts, we thought did not apply to Congress.
That's great. And then, Mr. Hunger, would you like to weigh in on this?
Sure, yes. Certainly it was always the position of the General Counsel's office at the House, and I'm sure still is, that the House is not obligated to recognize common law privileges. That dictum in the Mazars decision, though, may well come up in future cases that are litigated. So it may be something that Congress would want to address legislatively, just to remove any doubt.
Thank you very much for that. That was really my only question, though I do want to say to Mr. Fernandez, as a graduate of Brown University and the University of North Carolina, you have a very fine pedigree.
Thank you, Congresswoman.
Thank you very much, and I yield back.
Thank the gentlelady and Mr. Issa. I'm extremely reluctant to order a second round of questioning for fear that members on the congressional side would show up and yield you all of their time and you would be overexposed to the witnesses. So with that in mind, I will refrain from a second round. I will thank the witnesses for appearing before us today, and thank my colleagues for being here today, and this will conclude our hearing. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. And with that, the hearing is adjourned.